Hello everyone. This video will give an introduction to the intellectual property system. Let's get started with these questions. What are intellectual property rights? Intellectual property rights can be defined as the rights given to people over the creations of their minds. They usually give the creator an exclusive right over the use of their creations for a certain period of time. What are types of intellectual property rights under TRIPS agreements? Copyright and rights related to copyright. Then industrial property includes trademarks, geographical indications, industrial designs, patents, integrated circuit layout designs, and What is the TRIPS agreement? The TRIPS agreement stipulates a set of minimum standards for the protection of intellectual property rights that each member must follow in accordance with their individual national laws. All members have been obligated to uphold the national treatment responsibilities. Does the TRIPS agreement apply to all WTO members? Yes, it applies to all WTO members. For example, when I create my literary or artistic works in China, they are automatically protected in China and other WTO member countries.
This video will focus on two types of intellectual property, including copyright and patents. Next, we will explain the concept of the intellectual property system. Intellectual property system is a legal system in which the owner of intellectual achievements enjoys exclusive rights and is protected within a certain period of time. There are two parts to intellectual property. 1. Industrial property. 2. Copyright. The four components of the intellectual property system are creation of intellectual property, intellectual property protection, intellectual property utilization, and intellectual property enforcement. For example, the intellectual property system with regard to copyright, you have to create literary or artistic work, which is called intellectual property. Then your copyrightable works will be protected. The owner of the copyright will have exclusive rights to utilize his or her copyright works, such as licensing contracts, and only the copyright owner has the right to sue copyright infringement, either criminally or civilly. Let's start with the copyright protection system. In the first step is that you have to create your literary work or artistic work, which is called IP creation. Of course, some people may not be familiar with literary works and artistic works, and I will give you some examples. Literary works includes books, anthologies, journal and newspaper articles, reports, conference papers, working papers, computer software and programs, letters, emails, novels, poetry, song lyrics, databases, tables, and compilations. Artistic works includes drawings, paintings. In the second step, you should learn about minimum standards of copyright protection under the TRIPS agreement. Acquisition of copyright protection is automatic protection. Such as if you are a writer, your book is automatically copyrighted the moment it is created. Remember, the minimum standards of copyright protection last for the life of the author plus an additional 50 years.
What happens when copyrightable works expire? It's automatically in the public domain, which means anyone can use it without the copyright owner's permission. The copyright owner has exclusive rights. There are 5 fundamentally exclusive rights that the owner of copyright will receive: reproduction, adaptation, publication, performance, and display. Remember, you must obtain permission before using any of his or her literary or creative creations. What happens if I use his or her literary work or artistic work without his or her permission? This is about copyright infringement. 1. If copyright is misappropriated without the copyright owner's permission, the copyright owner has the right to pursue criminal punishment. 2. A contract or agreement has been signed, but the contract or agreement has been breached. Copyright owners have the right to pursue civil punishment. Remember, a licensing contract will help you to avoid copyright infringement. Furthermore, you need to make sure who is the copyright owner before you sign the licensing contract. With whom can I enter into a licensing agreement? If you want to sign a copyright licensing contract, you need to sign with the copyright owner only. Copyright is automatically safeguarded, as was already mentioned. Although you are not required to register your creative or literary works, doing so has 3 benefits. The ownership of your company is known to the public. You give your company the power to defend its copyrights. Statutory damages, legal fees, and court costs are all recoverable for your company. The copyright recordation procedure in Thailand is as follows. The Intellectual Property Office receives and verifies documents as part of the copyright registration process in Thailand. Applications are accepted and reviewed after submission, and certificates of copyright registration are then issued. The entire process typically takes 2-4 months to finish.
It's time to learn more about the patent protection system. Basically, there are two common types of patent, including utility invention and design patents. Some countries have plant patents like the US. All types of patents are granted by the government to inventors or industrial designers, giving the inventor or industrial designer the right to stop others, for a limited period, from making, using, or selling the invention without their permission. For the patent protection system, you have to register your invention or your industrial design with the government agency in the country where you want to protect it. This means that patents may not be valid in every country. Remember, if you are an inventor, you need to check the 3 requirements for patentability before filing a patent application: novelty, usefulness, non-obviousness. What destroys the novelty of invention? If you file a patent application for an invention that is similar or identical to an existing work before you file your patent application, that means your invention lacks novelty. Remember, the first to file rule for patent applications means that the application that files first receives priority.
The first to file rule applies to patent applications, allowing the individual who files the first patent to claim ownership of the patent's intellectual property. Remember, the term of invention patent protection is 20 years, counted from the filing date. The term of design patent protection is 10 years, counted from the filing date. I see that the term of patent protection begins with the filing date rather than the grant date.
Yes. For instance, the 20-year term of a patent, which begins on the application filing date rather than the day the patent is granted, means that your invention is protected beginning on the date you file the application.
The owner of the patent has the exclusive right to stop anyone who is commercially made, used, distributed, imported, or sold by others without the patent owner's consent. If I want to sign a licensing contract to contribute his or her invention, with whom can I sign a contract? For example, if you want to use or sell the invention patent, you need to sign a licensing contract with the patent owners only. If someone uses his or her invention patent without his or her permission, who has the right to enforce it?
For instance, if I possess a patent and someone tries to use it without my consent, his actions are unlawful and I can petition to the appropriate authority for prosecution.
Finally, we hope that this video will make the intellectual property system more understandable for you.
Even though it might be challenging to learn about intellectual property law, it can be useful if you know how to apply it to benefit your own business.